This open letter states that users of medical marijuana, even if authorized by state law, are prohibited from possessing firearms or ammunition under 18 U.S.C. 922 G3 because they're considered unlawful users of controlled substances under federal law. And then because your state recently passed Amendment 64, I come to this question, or three questions, but really dealing with just that subject. So I'll give you all three. Will you prosecute individuals who use marijuana in Colorado and possess firearms and ammunition as a violation of Section 922? Why or why not? And lastly, as the top federal law enforcement officer in Colorado, you're charged with enforcing federal law. Have you prosecuted anyone for violating Section 922 based solely upon medical marijuana use?
Senator, with respect to the first question as to whether or not we would prosecute people involved with marijuana for possessing firearms, the answer is yes, we have. In fact, we have a case out of Boulder County in which an individual was actually engaged in a grow of marijuana and possessed a variety of weapons, including some very nasty things called street sweepers, and we prosecuted that individual. With respect to whether we would end up prosecuting individuals solely because they had a firearm and were a user of a medical marijuana card, I think we'd have to look at those cases individually before we made any decision to determine whether that was the right allocation of our resources. I say that in part because the guidance we've received from the department is that, generally speaking, it is not the best use of our limited federal resources to go after individual patients who may be using medical marijuana.
Okay. Thank you very much for your answer.
Thanks.